Good morning, everybody. I'm delighted to welcome you this morning to our procurement webinar. Thank you for taking the time out of your busy schedule. For those of you who don't know me, my name is Dorothy McCann. I'm a partner here at Mason Hayes & Kern, and I head up our public procurement team. So today we will have two presentations. The first one will be from my colleague, Rory McDermott, who's a senior associate in our public procurement team. And he will speak about communications with bidders prior to the submission of tenders, and that includes market consultations. I will then speak about communications with bidders following submission of tenders, and that also includes, albeit only in brief, I will talk about debrief requirements. And following the two presentations, we will then have an opportunity for Q&A at the end. So please feel free to ask questions in the Q&A box throughout the presentation, and we will then go through as many of the questions as we can at the end. And we will also share the slides with you if you wish after this webinar. So before I turn to our presentation, I just want to mention a number of interesting cases which have come through the Irish and the EU courts this year. And I've listed them here, and I just want to briefly touch on some of them. So the first one is the Court of Appeal judgment in the Killary lighting case. And here the Court of Appeal largely upheld the decision from the High Court, which held that the contracting authority must investigate any tender which it suspects to be abnormally low. But interestingly, the Court of Appeal also clarified that in deciding whether a tender appears to be abnormally low, contracting authorities are permitted to examine the cost, the constituent cost elements of a tender, as well as the overall tender price. And this judgment is very interesting, and we've prepared a summary of this judgment, which you can find on our website. The next case is the Word Perfect case. It's gone through a number of installments, but this judgment relates to the right of authorities to divide procurements into lots and to put in place lot restrictions. And then the next case, the Kerrigan case, again, a very interesting case, but it relates to the disclosure of a successful tender's pricing structure and pricing information in the context of procurement litigation, so in the context of a confidentiality ring. The case of Dyka, which I've listed next here, it's an EU case, and that case related to technical specifications. And it's a niche case, but it's very interesting in that it states that if you mandate the use of certain materials, for example, in this case for water pipes, then you have to add the words or equivalence. In this case, the water pipes, the contracting authority said that the pipes had to be made of plastic, had to be made of clay or concrete, and the unsuccessful tender's pipes were made of plastic. And the court said no, that they should have allowed for or equivalent in the technical specifications. The case of Qingdao, that refers to the exclusion of an economic operator of a third country which hasn't concluded an international agreement with the EU. And this follows on from another case last year in relation to a Turkish tenderer. And in fact, since that previous case, it's been a call for the EU to publish a list of international agreements, as it can be very difficult for an authority to find out if a contracting authority from a non-EU country, it comes from a country which is subject of such an international agreement, which gives them equal protection under public procurement law. And the other two cases I very briefly want to mention here, they're both on modifications of contracts. So the first case is the Fastnet case. And here the European Court held that the unforeseen circumstances safe harbor in the concessions directive applies even where the concession was not originally awarded through a competitive tendering procedure. It's quite specific circumstances, but it's still a very interesting case to read. And then finally is another case on contract modifications. I'm not going to try and pronounce the name of the case. This was actually an advocate general opinion, and here the price included a fixed price where pickup point was within a certain radius, and then an additional price per kilometer outside that radius. And the extent of the radius and the price per kilometer was subsequently increased. And the Advocate General considered these changes, and they said that he said that they amounted to substantial modifications as they profoundly modified the structure of remuneration which had been provided for. But nonetheless, he considered that these modifications fell within the de minimis safe harbor. And he did so because the overall contract value had only changed marginally. Therefore, and he said that a substantial modification will only have the effect of altering the overall nature of the framework agreement, if that modification is likely to entail modifications which relate to the subject matter or the type of the contract. So really, really interesting judgment. And we are currently preparing summaries of both of these cases, which will be available on our website shortly. So please log back in to see when they will be available. Next page then. But today we actually want to deal with a topic on which we receive very many queries from clients, and that's communication with bidders. It's a very, very tricky area of procurement law, and the answer will often depend on the very precise circumstances of each case. But just at the outside, I suppose, to set the scene, it's worth noting that the extent to which contracting authorities can communicate with tenderers is always guided by the general EU principles. And I've listed them here: the principle of equal treatment, transparency, principle of non-discrimination and proportionality, and also the principle of sound administration. And we will see that in the case law, which we go through this morning. So these principles are very much the backdrop, and they should always be borne in mind when reaching a decision on this topic. And Rory will now take you through the key legal principles to bear in mind when communicating with bidders prior to the submission of tenders. So Rory, you can take it away.
Thanks, Doris, and hi everyone. So as Doris said, the first topic we're going to cover today is market consultations. I'm just going to touch then very briefly on clarifications to the tender documents, so before the tender deadline, as a last slide after this. So if we go to the first slide there, yeah, sorry, we're on it there. Market consultations, they're specifically dealt with in the Procurement Directive and in the regulations under Regulation 40, as well as Regulation 65 of the Utilities Regulations. And that sets out the main idea of them, which is that before the contracting authority commences the procurement procedure, it goes out to market with a view to helping it in preparing the procurement procedure and informing the market participants of its plans and requirements. Regulation 40 also states that for the purposes of conducting a market consultation, the authority can seek advice not just from market participants, but also experts in the field or other authorities as well. And lastly, Regulation 40 also lays out the main principles that govern the use of market consultation. So as Dart said, those are non-distortion of competition, and ensuring that there's no breaches of the principles of non-discrimination and transparency. If we go to the next slide there, please. Okay, so as regards whether to conduct a market consultation, there's no obligation to do so, but the OGP guidance does encourage authorities to consider undertaking market consultations on a case-by-case basis. So if we go to the next slide, please. Okay, so why should an authority consider conducting a market consultation? One of the major benefits is that it can alert the market to the procurement plans, which can increase interest. So in other words, a contracting authority can use a market consultation as a means of providing the market with early notification of a planned procurement opportunity. And this really kind of gives the market, time to react and develop its solutions, which is particularly important in larger complex contracts, a competitive dialogue, for example. It also has the added benefit of helping SMEs who often need more time, for finding partners for joint bidding or consortia bidding, etc. From the contracting authority's own perspective, conducting a market consultation also helps it enhance its own understanding of the market. In particular, it can help the contracting authority gauge market capacity. And this is actually quite important, as we've seen instances in the past where contracting authorities, they do all the prep for a procurement process, including finalizing all the procurement documents and incurring the expense of legal input into those, only then to find that when they actually go out to tender, there's no interest in the contract due to how the opportunity was set up. Whereas, if they'd conducted a market consultation in advance, this would have become apparent and they could have adjusted the procurement documents accordingly. Market consultations can also be useful for exploring innovative or alternative products or services, that mightn't have been immediately apparent, when you were, formulating the procurement. They can also help with risk mitigation. So, for example, a contracting authority might discover during a market consultation that certain additional risks exist that need to be covered off in the contract. They can help, with picking also the most appropriate procurement procedure, as well as refining your procurement documents and making sure that you don't have requirements in them that are inappropriate or might hinder the procurement process in some way. Market consultations can also reduce the volume of clarification questions you receive later in the process. And that's because, if you give bidders an early understanding of the approach and the requirements, well, then they're less likely to need to ask questions later on in the process. And finally, market consultations can also lead to shorter procurement times. So, for example, with complex procurements, again, using, say, competitive dialogue as an example, you often need to allow, for longer submission deadlines. And if tenders have, participated in the consultation, you might be able to reduce those deadlines down because, you've given them an opportunity to understand the requirements. But, you will always need to apply the minimum time period. So it's important to bear that in mind. Okay, so if we go to the next slide, please. Okay, so that was the benefits. In terms of the pitfalls, really the real danger with market consultations is that it can lead to an unfair advantage for participating operators, because those operators might influence the specifications or the criteria, which gives them, an increased advantage than over other tenderers. The other risk is that you can actually end up losing potential suppliers from the process. And this could happen, where suppliers are deemed to have been involved in the preparation of the procurement to such an extent, really, that there's, a distortion of competition. And the only option then is to exclude the operator from the procurement. And finally, one pitfall that we've come across, and that's actually, arisen in some of the cases, and we'll talk about this in a second, is that contracting authorities can sometimes view a market consultation as a sort of quasi-selection procedure. And what I mean by that is that they treat it as effectively part of the procurement process and use it to decide who to select for participation in the procurement process. And as we get into, this is actually quite problematic for various reasons. So if we go to the next slide, please. Before we do that, I just want to talk about some of the options for conducting a market consultation. So there are a lot of different ways you can conduct a market consultation, including open days, online surveys, workshops, etc. But really the key question for contracting authorities is whether you're going to conduct an open market consultation. So for example, where you advertise via prior information notice on OJU, and then engage with anybody who expresses an interest, or are you going to have, a closed approach where you just approach, a select few suppliers? And I think the first thing I would note is that there is nothing explicitly prohibiting a closed market consultation, but having a closed market consultation does raise the legal risk, because it is likely to be seen to be lacking transparency, and, it can lead to allegations of bias or unequal treatment. From a practical perspective as well, a fully open consultation also does have advantages. It allows you to get the widest possible feedback from the market. So, you can get the maximum insights that way. But it does have obvious disadvantages. So, for example, you will have to manage possibly a large amount of information received from economic operators if, there's a large interest in the market consultation. And we have found that some contracting authorities do find that impractical. Another disadvantage is that you might also get some reluctance from some suppliers to participate because they're worried effectively about their confidential information being disclosed to their competitors. We do also see some contracting authorities then effectively for this reason opting for a closed engagement approach where they just contact a select few suppliers. And the advantages of this are kind of the reverse of the open approach, which is, you can have more open discussions with economic operators and because, they're less concerned about confidentiality. And, But it does, like I suppose a major disadvantage of this is that it does raise the legal risk. One kind of way of offsetting that legal risk, I think, is to publish the results of the market consultation. We generally recommend that this is done in any event, and also a decision matrix as well, that shows, the information that was used, and what information was used for what decision. This also kind of helps start the clock as well from a legal risk perspective. It's very useful because, if somebody's going to take issue with the results or what you did in the procurement as a result of the market consultation, they'll be on notice of it very early on. If you are publishing the results, though, it is important to flag that to the participants, because again, there could be confidentiality issues with disclosure. So if we go to the next slide there, please. Okay, so as I said earlier, one of the kind of serious mistakes that contracting authorities can make is to treat market consultations as a sort of quasi-selection process. And the case of Consultant Connect and NHS is a good example of this. So this was a UK case which involved a procurement to supply communication services to 3 NHS care boards. And the plaintiff here, Consultant Connect, and 2 other companies were invited to make product presentations to the boards, which they were told was purely for pre-market testing purposes. What the companies didn't know, though, was that these presentations were marked against criteria that had been set by the boards. So the boards had effectively set criteria and then scored the presentations without disclosing this to the companies. Consultant Connect, so the plaintiff, got the second highest score, with another company that presented Synopsys scoring the highest. Following the presentations, the boards then decided to use a separate framework agreement that included Synopsys but not Consultant Connect, so not the plaintiff. The boards then engaged with 3 other suppliers on that framework agreement and then ultimately held a mini competition, but only invited Synopsys to tender. They then negotiated terms directly with Synopsys and awarded them the contract. So this was a case really where the contracting authority did, almost everything wrong, to be honest, and the court unsurprisingly declared contract ineffective and imposed a civil financial penalty. For our purposes, though, one of the key points that I want to focus on that the court took issue with was that evaluating candidates and their pricing without telling them goes beyond what's permissible from a market testing perspective. And the court here noted that, this market engagement, if you could call it that, was effectively used by the boards to establish which provider they wanted to award the contract to. In other words, the court found that the demonstration and scoring exercise carried out by the boards wasn't a permitted market testing exercise. It was in fact the first stage in a procurement process. The court also noted that if the exercise was a market testing exercise, it was one that had the effect of distorting competition and resulted in a breach of the principles of non-discrimination and transparency. It's also just worth mentioning, this actually doesn't appear to be a once-off or not too infrequent. We've actually come across instances of contracting authorities using supposed market consultations as kind of quasi-selection processes. And for example, one instance, we had a contracting authority decide that following a market consultation, it was entitled to award a contract directly to its preferred supplier on the basis that there was only one possible provider. In other words, it was trying to rely on this derogation in the regulations that permits a direct award of a contract, or a negotiated procedure without prior publication, in cases where there's only one possible provider. And really the issue with this is that just because somebody doesn't participate in a market consultation doesn't mean that they wouldn't tender. You often get cases where economic operators decide not to participate in a market consultation, for a variety of reasons, including the confidentiality issues that we talked about, a few moments ago. So you can't really rule out there being other providers just on that basis. And the courts have actually been very clear on this. There needs to be extensive research done at EU level in order to reach that conclusion, which a market consultation just wouldn't satisfy. It also raises, kind of the same issues that would have cropped up in this Consultant Connect case, issues such as transparency and equal treatment due to the undisclosed intention of the contracting authority. Okay, so if we go to the next slide there, please. Okay, so to sum up in terms of the do's and don'ts with regard to market consultations, in terms of the do's, as a contracting authority, you are free to decide how and who to conduct a market consultation with. as long as it doesn't have the effect of distorting competition or violating the EU principles. That means you can do a fully open consultation, or you can do a more closed consultation. But there is more legal risk with a closed consultation. It goes without saying that you need to treat all potential suppliers equally, and that can be achieved in part by making all of the information available, which was available during the market consultation. So making it available to all the potential tenderers, in the procurement process. We always advise that you retain very detailed records of the process and the conclusions, and that you document those records for the decisions that you took, and that you then publish that information so that all the tenderers in the tender process have the same information. If we go to the next slide, please. In terms of the don'ts, again, the big ones are not to unduly favor any of the participants in the market consultation or disadvantage any other particular supplier, not to distort competition or violate any of the EU principles, for example, transparency. And finally, just to be very careful that you're not making a determination as to who you're going to award the contract to based on the market consultation. Because fundamentally, the market consultation is not a procurement process, and you can't use it as the basis to award a contract to a particular supplier. Okay, so if we go to just the last slide that I'll have then. And actually, it's one more slide. So the last area I wanted to cover was the question of clarifications, and in particular clarifications of the tender documents prior to the tender deadline. And as I said, Dart then is going to take a look, or going to go over communications with bidders and clarifications after the tender deadline. So from a tenderer's perspective, why is it important to seek clarifications? Often tenderers don't raise clarifications because number one, they don't want to annoy the contracting authority, and number two, they'd rather wait until later to see if the issue actually materializes. But actually, from a contracting authority's own perspective, clarifications are really useful, and they allow the authority the opportunity to address any mistakes before the procurement process goes on too far. And from a tenderer's perspective, it's much better to see clarifications early on, because the time limit to bring a procurement challenge is generally 30 days from the date you knew or ought to have known of the infringement. So if a problem arises in the tender documents or a process down the line, and you leave it until the time of, say, the standstill letter to query it, well, then you're generally going to be out of time. Having said that, clarifications do raise some legal issues that it's important to be aware of. And the first of these is that, as a contracting authority, you need to ensure that you're treating everybody equally. It's the same principle all the way through. So, for example, if you're giving information to one tender, you're giving it the same information to the other tenders. The second point to watch out for is that if you provide a clarification that's very significant and it's close to the clarification deadline, you may need to extend the deadline further so as to give tenders enough time to adjust their tenders. The other related point to bear in mind is that if your clarification effectively results in a change to the tender documentation, you'll need to consider if it's a material change. And if it is, you may need to either republish the RFT and effectively restart the competition, or else go back a stage in the procurement and allow the change to be taken on board by tenderers. So, for example, with a restricted procedure, it might be possible just to go back to the stage after qualification without having to fully restart the procurement. And finally, it's just worth mentioning that there is this, kind of slightly tricky tension between balancing your obligations of transparency and equal treatment with your obligation not to disclose confidential information of tenderers. So, for instance, if a tenderer submits a clarification and labels it as confidential, what should you do in that situation? Well, really, the default position is that responses to clarification queries should be sent to all tenderers. And it's only in very exceptional circumstances that you should deviate from that. But if a tenderer has marked their query as confidential, and you think that that's reasonable, the response could perhaps then just be sent to that one tenderer. On the other hand, if you think it's not reasonable for the tenderer to have marked the query as confidential, you might decide that the response can be sent just to that one tender, and you should advise that tenderer then of that and give them the option. Sorry, you might decide that the response can't be sent to that one tender, and you should advise the tender of that and give them the option of withdrawing the query. Okay, so that's it from me in terms of communications with tenderers prior to the tender deadline. Dart's just going to continue on now with clarifications on other communications after the tender deadline. So over to you, Dart.
Thanks, Rory. And Yeah, I can only echo what Rory said. Clarity and is key in the tender documents. And if a clarification, many clarification questions are raised, it might be a sign that the documents are maybe not as clear as you thought they were, and you should use that opportunity to clarify your tender documents and perhaps even to republish the RFT in its entirety. But I will now look particularly at the issue of clarifications of tenders after they have been submitted. And it's a very, very tricky question. And there's quite a bit of case law on that. And I'll consider some of those cases. So worth here, I've replicated Regulation 56.4 of the classic public contracts regulations, and then also the same wording applies to the utilities regulations. And you can see here there's quite a wide discretion where information or documentation submitted by an economic operator is or appears to a contracting authority to be incomplete or erroneous, or where specific documents are missing, the authority may request the economic operator concerned to submit, supplement, clarify, or complete the relevant information or documentation within an appropriate time limit, where any such request is made in full compliance with the principles of equal treatment and transparency. And this wording was added for the first time in the 2014 directives. So on the one hand, the first part of this provision appears to give authorities a very large discretion to clarify tenders or request missing documents. However, the caveat in the that I've highlighted there in the final couple of lines is a very strong caveat, and that obviously states that any clarification must be subject to the principles of equal treatment and transparency. And those principles would generally not allow authorities to permit tenderers to rectify their tenders after the tender deadline. As of course, if you're only allowing one tenderer to rectify their tender, then this gives arguably that tenderer an advantage over the other tenderers who complied with all the requirements within the deadline. So if you go to the next slide, then I want to jump first into the straight into the case law. And the first case I want to look at is that of ADIA Interim, which related to a tender for agency staff. And here, tenders had to calculate net and gross hourly wages and hourly billing rates. And it's quite a complex calculation, which included reference to pay scales and social security and tax, etc. And the evaluation panel discovered a systematic calculation error in relation to one of the tenders. And they determined that that calculation error couldn't be easily resolved. And they therefore excluded that tender from the procurement process. So that tenderer then brought a challenge and claimed that the European Commission, which was the contracting authority here, had infringed the principles of equal treatment and transparency, equal treatment and sound administration, in not correcting the error or in not asking for clarification from the tenderer. And the court sided with the European Commission and said that the error in this case could not have been corrected easily, and any attempt to correct or clarify the error in this case would have involved a risk that other factors would be taken into account in order to establish the correct tender price. And this would have led to a breach of the principle of equal treatment to the detriment of the other tenderers. So if you then go look at the next case on the next slide, it's another EU case. And this is, again, a very interesting case here. One of the minimum requirements which the contracting authority had set was that candidates had to submit a copy of the most recent balance sheet of the company. And two candidates hadn't submitted their balance sheets with their applications. And the contracting authority requested them that they send in a copy and after the application deadline. And the Court of Justice was asked to look at this, and they held that a request for information or documentation is not in breach of the principle of equal treatment where certain conditions are met or in certain circumstances. And this is where the information objectively can be shown to predate the deadline. So in this case, we were talking about a balance sheet which was publicly available, I think either on the company's website or on the company's register. It could be shown that this had been prepared and was available before the deadline. The tender documents didn't state that a failure to comply with the requirement will result in automatic exclusion of the tenderer. And the request for information must not unduly favor or disadvantage the candidate in question. In other words, the request to clarify the tender, to supplement the tender, must not lead to the submission of what's in effect a new tender. So very helpful principles and guidelines to bear in mind when a tenderer has perhaps forgotten to submit a document which was meant to be attached to its tender. On the next slide then, I will look at the case of another EU case of Arcus and Gamma. And this was a case which related to digitization of documents, and tenderers again had to attach documents to their tender, and one of them included a sample of a microfilm. He actually was the tenderer which contacted the authority because they realized that they had submitted the wrong sample. And it's worth noting that Regulation 56 doesn't actually account for those circumstances. It only covers the situation where the authority requires clarification. There's no express provision for the tenderer submitting a rectification without a request. But obviously, in practice, the tenderer can just alert the authority to the error, and then the authority can request a rectification if it wishes to do so. But in this case, the authority ultimately rejected the tender. It allowed a revised sample to be submitted, but ultimately rejected the tender on the basis that neither sample satisfied the requirements. The court confirmed a number of important principles here. And the first principle is that once submitted, a tender can no longer be amended. So that's the kind of the baseline, I suppose. And there's no obligation on an authority to clarify or correct tenders which are ambiguous or incomplete. But in certain circumstances, a correction or amplification of a tender is permitted, where clarification is clearly needed or where there are obvious clerical errors. And in order for such a request or such a clarification to comply with the principles of equal treatment and transparency, any such request should only be made after the authority has looked at all the tenders, because they need to treat everybody equally. Also any such request should be sent in an equivalent manner to all tenderers who are in the same situation, and should not lead to the submission of a new tender or unduly favor or disadvantage a tenderer. But it's worth bearing in mind when the court here talks about tenderers being treated equally who are in the same situation, that does not mean that the mistake must be identical. Very rarely is there an identical mistake made by two tenderers, but the mistake needs to be comparable. So for example, let's say a certain section of the ESPD wasn't properly filled in, or they forgot to tick a box in the ESPD or something like that. It doesn't need to be the same box, but it needs to be comparable in some way. So if you then look at the next case, this case is a little bit different here. In this case, actually, tenderers had to confirm that their tender would remain open for acceptance for 90 days from the deadline for the submission of tenders. But then after publication of the contract documents, the authority changed the description of one of the lots. Because they changed the description, they extended the tender submission deadline to allow tenders to take account of this change and to basically make corrections to their tender. The claimant resubmitted the original tender response, but they forgot to amend the expiry date of the tender validity period. So it was in their tender, it was still calculated as being 90 days from the original tender submission deadlines. And the authority therefore held that the tender was non-compliant and rejected the claimant's tender as being non-compliant. But in those circumstances, the court stated that while evaluation committees are not obliged to seek a clarification in every case where a tender is ambiguously drafted, they do have to exercise a certain degree of care. And where and this is especially so where the ambiguity has a simple explanation and is capable of being easily resolved. And in those circumstances, it would be contrary to the principles of good administration for an evaluation committee to reject the tender without exercising the power to seek clarification. And they went on to say that a decision to reject the tender in such circumstances is liable to be vitiated by manifest error assessment. So in some limited circumstances, a duty to allow rectification of an error may arise from the principle of proportionality and the requirement of good administration. But I would say that this is only really very limited circumstances. So they have to be very obvious and minor errors. And they can't obviously, there's no duty to allow clarification of a tender, but this would modify the substantive terms of a tender. And the last case I'd like to look at is the case of Robert Owens, which is an Irish case relating to a framework agreement for building maintenance works. And here, the claimant not only failed to submit a quality submission, which had been required to be submitted, but they also had a large number of pricing abnormalities in their tenders, which amounted to some over 400 pricing abnormalities. And the council ultimately, they gave the tender an opportunity to clarify or supplement their tender, but ultimately they rejected the claimant's tender. And the claimant then alleged that it had been treated unequally, as the other tenderers also had pricing abnormalities. And they had been asked to adjust or increase their price on specific items, but and the claimant said that no such specific guidance had been given to the claimant. And the court held that the principle of equal treatment does not require that all participants must be treated identically. And they looked at the different situation in which the other tenderers were in compared to the claimant. So the other tenderers each had less than 10 pricing abnormalities, whilst the claimant had over 400 pricing abnormalities. And they said that the court said that they just were not in the same position, and that they were in fact in a radically different position, and there was therefore no unequal treatment or unfair discrimination against the claimant. So if you go to the next slide, then just to recap some of the general principles which emerge from this case law. So in principle, once submitted, tenderers can no longer be amended, and contracting authorities shouldn't allow tenderers to amend their tender. There's no general duty on authorities to allow a tenderer to correct errors in a tender, but authorities are generally permitted to seek minor confirmations or clarifications of information which has already been submitted. So, for example, inconsistent or contradictory information, unclear description of products or services, or some other minor mistakes or omissions. And it might even be permitted to supplement whole documents if they're missing. But in that case, it must be shown that those documents predated the deadline for submission of tenders. And I suppose, again, the kind of guiding principle is that the rectification of errors is not permitted if it would, in effect, lead to the submission of a new tender. So I think kind of supposed to wrap up on this point, the submission of a significant number of documents or information relating to the merits of a tender will in most cases amount to a new tender and therefore would be prohibited. But obviously, there is a huge gray area in the middle between what's a minor clarification, which is permitted, and between the major kind of clarification, which effectively amounts to the submission of a new tender. So if in doubt, I suppose the safest way might be to have a second round of tenders, where all tenders are given an equal opportunity to clarify or correct their tenders, provided the process is transparent and everybody's treated equally. But, even with that, care would have to be taken. And really, if you want to go down that route, that should be provided for in the tender documents in advance, so that tenders are on notice that this might happen. And then the final principle on the next slide, as I mentioned in the Tideland case, in very rare circumstances, there may be a duty to seek clarification where there's an obvious error which is capable of being easily resolved. But again, as I said, this duty only arises in very limited circumstances. Just then to go to the next slide, finish with some final tips, I suppose. The case law, I think, clearly emphasizes the need to clearly set out all the requirements in the tender documents, so that the error doesn't arise in the first place, and also to ensure that the tender response document aligns with the requirements in the IFT. So sometimes we see a lot of requirements listed in the IFT, but then when you look at the tender response document, there's no place in it for tenderers to actually submit that information, and that can be an issue, and that can lead to errors or omissions by the tenderers. It's also important to set an appropriate time limit for rectification, and that's set out in Regulation 59 first, to an appropriate time limit. And then finally, obviously, good record keeping is absolutely essential in explaining which processes the authority has followed and why it has followed them, and in being able to justify the reasons as to why certain decisions have been reached, as to why the authority has asked for clarification or not asked for clarification. Next slide then. So I very briefly would like to, and I'm conscious of time here, to look at debriefs after the procurement process has been concluded. And I will not go through all of the slides in detail, but if you're interested in getting the slides, please let us know and we'll send them out to you. So if we go to the next slide, then I've set out here the requirements contained in remedies regulations. And it's important to note that these requirements are supplemented by Regulation 55 in the Public Contracts Regulations, and which state that the authority must inform each candidate or tenderer the decision reached as soon as possible, and that if the candidate or tenderer sends a written request to the authority, even where the stance letter has already been sent, then the authority must respond to that request in writing from the candidate within 15 days. And that's an additional requirement. It's not instead of the stance letter. So if we look at some of the cases on debrief requirements, the leading case is that of RPS Consulting Engineers, which is on the next slide. Really what that case highlights is that an authority must give sufficiently precise and bespoke reasons to enable an unsuccessful tenderer to ascertain the matters of fact and law which led to the rejection of his tender and the acceptance of another. They must know why they lost and why the successful tenderer gained a higher score. So vague and general references to the manner that your tender was good, but a successful tenderer was better, that is very clearly insufficient. So the RPS case set a pretty high hurdle which authorities have to meet in providing very bespoke and specific reasons. If we go to the next slide, then the case of relating to ferry passenger services to Tory Island demonstrates this very clearly. Here, the court was very critical of the reasons which had been provided and said that they were bland and did not allow the unsuccessful tenderer to identify why they lost the marks. And you'll see here some of the kind of debrief information which was given to the tenderers. I want to finish then with a final slide, and that's coming back to the Achille case, which I mentioned at the very outset, with the Court of Appeal judgment on the next slide, which was handed down by the court earlier this year. And here, Hillary had been sent a letter by the contracting authority, and it was told that it had been excluded. But this letter was not a full standstill letter. It didn't identify the successful tenderer, and it didn't give any details of any standstill period. And I've replicated here some of the wording, the main wording from that letter. So by the time Hillary issued proceedings against the contracting authority, the contract had already been signed. And the court held that the council's failure to send a compliant standstill letter deprived Hillary of the chance to seek remedies before the contract was signed. And in these, and so therefore, the letter that had been sent was not a compliant standstill letter. The Court of Appeal also held, though, in this case, that in certain circumstances, a summary of reasons may be sufficient to be given. And this was the case here, as the reasons for why the unsuccessful tenderer had lost were obvious from the various documents, such as the request for tenders, the earlier correspondence, and from the context of the decision itself. And so, but I would treat this case with some caution, I suppose, because, as I said, the RPS case sets quite a high hurdle on the kind of debrief requirements which have to be contained in a fully compliant standstill letter. So with that, I will now look at some of the questions that, oh, sorry, my apologies. I forgot a slide. So I just finished with, I suppose I just have some do's and don'ts here in relation to standstill letters, which basically replicates the cases which I've mentioned. So bespoke reasons must be given which are sufficiently precise. They must refer to specific matters, and more detailed reasons have to be given if the successful tenderer won on quality, and where the unsuccessful tenderer was cheaper compared to the successful tenderer. And then on the next slide, if you look at the at some of the don'ts, one of the helpful things is actually where the unsuccessful tenderer has scored the same or higher mark on any award criterion compared to the successful tender, then you do not have to give any detailed reasons. So that is the one helpful aspect for contracting authorities that flows from the RPS case, where the unsuccessful tenderer has actually received the same or higher marks. You basically don't have to give any detailed reasons. But generally speaking, avoid generic language, and don't limit your feedback to scores alone unless unless it relates to the price. So I will have a look at the questions, and there's loads of questions actually that have come in. So let me scroll through them and have a look. I see a couple here on market consultation. So maybe if I start with one for Rory. If you're only engaging with one or two operators during the market consultation, do we then need to exclude them from any resulting procurement process?
Thanks, Dart. So I suppose from the point of view of excluding someone, it doesn't really matter how many others you engage with in the market consultation. So even if you do, a fully open consultation, you might actually still need to exclude somebody. Having said that, it is actually very rare that you would need to exclude somebody. It's something that we haven't seen. The only thing really that matters in terms of the considerations is whether that person's prior involvement would lead to a distortion of competition if they were allowed to participate. And really the first thing to note is, the only time you should exclude somebody is where you've exhausted all the other avenues to neutralize the impact of the prior involvement. For example, you should first have considered whether providing information to other participants or extending the deadline would neutralize that impact. And it's also just really important to remember as well that the participant that you're intending to exclude, they have to be given the opportunity to prove that there's no distortion of competition. This is actually in the regulation as well. And it's only after all of that, if there's still a distortion of competition, that it's okay to exclude that tender.
Yeah, I can only echo that. I mean, you have to be very careful before you exclude somebody who's been involved in market consultation. I would go so far as to say that you probably shouldn't do that before seeking legal advice, because clearly them having spent time and money on the market consultation, they'd be rather aggrieved if they're not then permitted to tender for in any resultant procurement exercise. Another question here, market consultations. Is there less risk in just going to experts instead of market participants or potential tenderers? Do you want to take that, Rory?
Yeah. So I think, in short, yes, there is likely to be less risk, because I suppose fundamentally the people that you're consulting are not going to be participating in the procurement process. But having said that, there is some risk probably still of favoring a particular supplier, because you might do it unintentionally, or one of the experts could actually just be connected to a supplier in some way that you don't know. So you do need to just consider whether objectively you're taking what they say, and if it results in favoring a particular supplier, even if it's just experts.
Thanks, Rory. I'm just going through the question here. I think I might take this one. So what if several tenderers make similar mistake in their tender, but one of the tenderer does not meet other selection criteria in addition to this one similar mistake? Does a request for clarification need to issue to all of the tenderers? So I think what's intended here is, let's say all of the tenderers don't fill in the ESPD correctly. I keep going back to the ESPD because that's what we see a lot, the ESPD not being filled in correctly. But so what if a lot of all of the tenders, let's say, don't fill it in correctly, but then one of the tenders also doesn't meet one of the other selection criteria? Maybe they didn't meet the turnover requirement, let's say. So in those circumstances, I think as long as it's clear that the tender has to be rejected for other reasons, so in this case, not meeting the turnover requirement, then you wouldn't have to give that tenderer the opportunity to correct their ESPD, so the mistake that tenderer has in common with all of the tenderers. So equal treatment doesn't really apply here, because that tenderer is in a different position to all of the other tenderers, because he's already, or here, that company is already being excluded for a different reason, i.e. not meeting the turnover requirement. So I think there's an objective justification here for treating that tenderer differently. I hope that answers the question. Another question then is, if we get a clarification question and we answer it, and then actually this happens quite a lot, and then we receive another follow-up clarification question, but this follow-up clarification question is past the clarification deadline. Can or should we answer that second question? I think, Rory, do you maybe want to take that one?
Yeah. So I think the answer kind of depends. It depends on the question itself, and also what you want to do. There's no obligation to answer the question because it's past the deadline. But if you do want to answer it, then you need to consider if the response to the question will be equally of benefit to everybody. And if that's the case, then it's probably fine to answer the question, even though it's past the deadline. But on the other hand, if the response would only be a benefit to the company that asked the question, then you should probably extend the clarification deadline for everybody. I think it is also just worth saying that, the safest thing to do in most cases is to just extend the clarification deadline for everybody. But that's, that might not be very attractive because, you might then invite further clarification requests from others that are unrelated to those clarification questions. So, yeah, I think that should.
Yeah. Yeah, no, I think that's right. There's another good question there, and again, something that we've seen a number of times. What if one tenderer it doesn't miss a whole document, but the page within a document is missing? So basically, when it was uploaded, one page was missed. Can or should this be requested from the tenderer? Yeah, this is an interesting one. I mean, as we've heard in the case law, so even if there's a whole document missing, that can be requested. Again, I think there's unlikely to be there's not an obligation here for the authority to request this missing page. But I think it's likely that that there is a discretion here to ask for this missing page and to allow the tenderer to submit this. But to be safe, I think I would say that the authority should also seek evidence that that page or that the entire document was existed prior to the expiry of the deadline. So just to be on the safe side, to make sure that they're not being given an unfair advantage by submitting this additional page. And this is kind of a little bit in contrast to the situation, for example, where a tenderer has missed responding to a question in a tender response document. So, maybe there's a question there on providing some methodologies, and then maybe there are a number of questions and they've just totally missed 2 or 3 questions at the bottom of the page. That would be more tricky, because if you're allowing the tenderer to answer those questions now and to submit that additional information, that could well amount to breach of the principle of equal treatment, because in those circumstances, it would be almost impossible to prove that the document there is no document which could have existed before the deadline. So this is information that the tenderer would draft in response, and so the risk there would be much higher. But if you have maybe a document or a page of a document missing, then if you can prove that that document existed prior to the deadline, the risk is much lower there for the authority in asking for that to be submitted. Just looking, we might have time for just one more question before we finish up. What if an error is made, but actually that error is due to a mistake or a fault of the contracting authority? And this is actually very interesting, because this is not something that is explicitly set out in the directive. But there probably is, well, in those circumstances, there certainly the authority is permitted to allow rectification of the error, and there may even be a duty to allow that tenderer to correct the error, which is the fault of the authority. And if I remember correctly, there was a recent EU case where tenderers were required to list certain costs in their tender, but actually the tender form didn't allow those costs to be listed. So there was a discrepancy between the requirements in the IFT and in the tender response form. And in those circumstances, the court said that the authority was permitted to allow corrections of the error. But from memory, the court didn't go so fast to say that there was a duty on the authority to permit the tenderers to correct the error. So this is a very tricky one, and the recommended course of action may well depend on the circumstances of the case. So, for example, did all tenderers make the same mistake? Did all tenders make the error because the authority had missed something or was at fault in some way. And if that is the case, then the best course of action might be to highlight the error the authority made to all of the tenderers, to give all tenderers an opportunity to rectify the affected part of their tender, and to give all tenderers a new deadline. But it really depends on what sort of mistake we're talking about here, and how easily it can be rectified by the tenderers. So I'm conscious of time, so I hope you found that interesting. As you can see, lots of tricky issues in relation to this area, and it is one where we receive many questions from clients on a weekly basis, if not a daily basis. But if you would like any more information, or if you have any follow-up questions on any of the topics raised today, then please feel free to get in touch with either Rory and myself. And as I said, if you want to receive the slides, then please feel free to get in touch. And there's also a survey which will pop up at the end of the webinar, and I would ask you to fill that in to get some CPD points. And I suppose of particular interest is to us any topics you might want to hear about in future webinars, or whether you prefer, for example, an in-person event over a webinar. So any suggestions you have for future events would be very helpful. But in the meantime, I hope you have a lovely day, and thanks again for joining us today.